And moving on, so we'll be moving on next to our presentation updates to the Brown Act, Public Records Act, and California ethics law. And we have City Attorney Brewer and Assistant City Attorney Contreras here to present.
Okay, I'll get things started. I'll share my screen here. One moment. Okay. Okay, does everybody see my screen? Okay, great. All right, well, everyone, as you may know, my name is Robbie Contreras. I'm an assistant city attorney here with the city of Carlsbad. Before I introduce our city attorney, I wanted to just orient us on why we're here today. You may remember back in June of 2020, we had a foray into the Public Records Act and a little discussion on that. The commission requested a more complete presentation on public records. So here before you today is a kind of an update on the Brown Act, public records, and ethics law. So I'll now introduce our city attorney, Celia Brewer, who will take us through to the next slide.
Next slide.
Okay.
There we go. There's my beginning slide. So thank you, everybody. I'm really happy to be here. I'm very, very sorry that it can't be in person. And I want to say at the outset that this is what I call a little mini training or update. And by no means does it replace the need to get your 2 hours long ethics training that goes over all of these topics in great detail. Nonetheless, we haven't been teaching that class here at the city. We used to teach it a couple times a year. I suppose we could still do it by Zoom. So we thought it was worthwhile to do this and update you on some of the changes that have come. So I'm going to, for all those of you who have seen this presentation, I might repeat some material. For those of you who are new, hopefully you'll at least be familiar with it. Next one. So the Brown Act is our primary transparency law, and what it says is that all of the people's business needs to be done in public, and that includes not just making the decisions in public, but it means that your deliberative process should also be open and accessible to the public. What that means in English is that they should understand the reasons for your decision making, the factual materials that you're basing your decisions on, etc. I always love this preamble to the Brown Act because it's so clear. Sometimes the legislature is not so clear. But in this case, it's one of my favorite quotes, and it says, "The people, in delegating authority, do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments that they have created." And I say this because you will find that judges interpret this act in accordance with this preamble, and that is that it's generally interpreted to favor the public's right to know. In all circumstances. I also want to make sure that those of you who are interested in the Brown Act have received a copy from our city clerk of the book Open in Public. It's a league publication, and it's a very nice, accessible presentation on the Brown Act. So I highly recommend you get that. Next slide. So the gist of the Brown Act is that you have to have meetings that are publicly noticed with an agenda, and it has to be open and accessible to everybody. So who does it apply to? Technically, it applies to legislative bodies of local agencies, and that includes both people who are elected and people who are appointed. It also applies to any the agencies they create. So let's just pretend that your 7-person traffic commission, traffic and mobility and safety, decided to have a subcommittee of 4 people to consider something else. The act of creating that would subject it to the Brown Act as well. So funding can also create a Brown Act committee. Let's see if I have anything else. Interestingly, it applies to the decision makers. So it applies to all of you. You may not be making the final decision, but you're making decisions on recommendations to the city council. But it doesn't apply to staff. We're not actually capable of violating the Brown Act ourselves because we're not the decision makers, but we could facilitate a Brown Act violation by sharing information between one commissioner and another. So staff is always trained in this as well and very careful and wary not to do that. I can't see you all in these Zoom trainings, so if anyone has questions, I think you can raise your hand, or we can have time for questions at the end because I do like questions. So the next slide, please. I think we just went all of this. This is the governing body of the agency. You are the governing body of the agency. It does not apply to your ad hocs, but it does apply to others. Next slide. What is a meeting? It's any congregation of a majority of the members. So in your case, it would be 4 members at the same time and location, including teleconferences, to talk about anything that's within the subject matter jurisdiction of your body. There are some exceptions. They're pretty limited. You could all attend an educational conference, for instance. You could all go to a social and ceremonial event. But just remember what it looks like to the public if 4 of you were together at a table talking, even if it was a Christmas party somewhere out in the community. People would have a tendency to assume that you're talking about the business within your agency. So I really discourage that. I really discourage people recognizing that you're building the public trust when you're out in the community. So even if you are talking about football or your pets or your vacations, the public doesn't necessarily have a right to see that. It might, or to know that, and they can't necessarily see it. So next slide. When does the Brown Act apply? We just talked a little bit about this. It applies every time you're having a meeting. We know about open notice meetings, but what about other types of meetings? And this is something that's a little bit difficult because the Brown Act says that you can't have what they call serial meetings. And serial meetings can take place when A talks to B, who talks to C, who talks to D. All of a sudden you have consensus building outside of a public meeting. It can also take place when A talks to B, and then A talks to C, and then A talks to D. So you're not supposed to be doing that opinion shopping or trying to build consensus under any circumstances. What you're supposed to be doing is looking at your agenda materials, coming to your meeting, and then asking your questions, and then becoming educated in the topics. Now, that doesn't mean that if you need a clarifying question answered when you get your agenda materials, you can certainly ask your staff member, will you be prepared to address this at the meeting? But it is very tricky to make sure that you don't have gatherings that are inadvertent. I call those inadvertent Brown Act violations. It's a little bit harder to do with you because you're a bigger body, but for the city council, it means that really all you have to do is talk to 2 people and you've committed a Brown Act violation whether you meant to or not, if you're talking about the same subject matter. So if let's just pretend one of you has already talked to 2 members and the other person is coming up and they've talked to another member. When you talk, you're adding up all those members. So the best way to handle the Brown Act is to say, I'd like to talk to you about an upcoming agenda item. I've already talked to one other person. Have you spoken to anybody about this? And if they say, yes, I've spoken to 2 people, say, okay, I can't talk to you until the meeting. Does that make any sense? This Brown Act is considered an obligation of office. All of you are expected to know this and comply with it. And so therefore it comes with personal responsibility. Sometimes I have bodies that think that the Brown Act is something that only the city attorney applies and only in the context of a meeting, but actually it should sit on your shoulders and be a weight on you and inform your conduct at all times while you're a city representative. Okay. So now let's get to the kind of the fun thing. Next slide. Which is, we just talked about this. Next slide, please. So this is kind of fun because you've all heard me talk about, or those of you who've heard me speak on this before, about the fact that the law often lags technology. And the Brown Act is something that lawyers really struggle with technology. When email first came in and people were able to do something like a constituent would write in and say, I have an issue with this street sign or this stop sign. If 4 of you started saying, I hear you, and I don't think we should have it there, and the next person said, well, I like that stop sign, all of a sudden, with that reply all button, which people usually hit to be considerate, we were having inadvertent meetings. So all of us city attorneys, we were really did a yeoman's job and trained everybody, never used the reply all button. But the fact of the matter is technology then far outpaced us again. We've developed all these new social media platforms. We have TikTok, we have Twitter, we have Reddit and Facebook and Instagram. I don't even understand how some of these work. But once again, we've developed a platform that went before the law. So just recently, in fact, on the 18th of September, the governor signed a new addition to the Brown Act, and it has to do with social media. And what it says is that a member of your committee or commission is allowed to participate on social media. You can, for instance, put something on your own Facebook page and say, this should be of interest to my constituents and the people who follow me on this page, and you can put it out there. What the law specifically says, though, is no other member of your body can then comment on it or like it or do a thumbs up on it or screenshot it and post it on their own. And that seems a little bit harsh at first until you consider some of those things that I just said. And also remember, sometimes people participate on social media with anonymous names or handles or whatever you want to call them. So it's not even always clear who's on that. So that's why it's incumbent on you to follow this rule. But let's just pretend, and I'm going to use the council again as an example. One council member posts something, another council member puts a thumbs up, and a third council member sees that. The Brown Act has specifically been extended to include deliberative gathering. Deliberative gathering. So if you're out gathering facts, even though it doesn't look like to a member of the public that there's been 3 people creating a majority in that social media situation, the member who has viewed that is getting facts about where people stand on an item, and maybe it's even helping them formulate their position, and it's not being done at an open, honest public meeting. So I think you all can see why that would be problematic. So we don't want to have any kind of behind the scenes collective gathering of facts. So this also applies to other actions, texting, of course, swiping. I don't really know what swiping means, but if you can keep track of swiping, I know liking, but it applies to any of those actions that you can take in response to a digital posting. So this is new. It's only a couple, 3 weeks old, and it's one of the reasons that we decided that we wanted to give you this little update. Again, this material will be included in the AB 1234 ethics training, and you'll get a chance to address it there. So I am next going to turn it over to Robbie to do the Public Records Act, and then at the end, I'm going to give you a couple other updates on some issues related to conflicts of interest and bias. Robbie?
Okay, so the Public Records Act and I go way far back. Before coming to Carlsbad, I did a lot of work on Public Records Act issues, so this is near and dear to me. One of the things, just like Celia was saying, that inform judges on the Brown Act, judges often cite to the legislative history of the Public Records Act and finding that every person within the state, and really anyone outside the state, has a fundamental right to inspect public records of any public entity. And that is taken very seriously in the courts. So really, when you think of what is a public record, the easy answer is pretty much everything. As you see there, any writing that contains information regarding the conduct of the people's business that the public entity owns or retains or is within constructive possession even of the public entity. So again, it can be a picture, it can be a text message, it can be any kind of recording, an audio recording, a CD, you know, it can be any number of things that relate to the conduct of the people's business. So again, like I said, this right is enshrined in our state constitution. Other examples of what a public record is include the agenda for each and every publicly noticed meeting. The other writings, you know, emails are also included as being public records. And what's interesting is that if there's a Public Record Act request from a member of the public to inspect or get a copy of these records, if the member of the public feels that this public entity is withholding a record that the member of the public has right to see, the Public Records Act has a whole procedure for enforcement and allows this requester to go to court and seek assistance from a judge to order a public entity to release records that are responsive to the requester's request. So the timeframes are pretty short in the sense that a public entity must, within 10 days of the receipt of the request, acknowledge that the public entity has received the Public Record Act request, and then must, within the context of what's being requested, promptly make copies available for inspection and release. One of the more interesting areas here includes, Government Code Section 81008 with records under the Political Reform Act. There's includes Form 700 and other types of documents along those lines. Really, the public entity doesn't have much wiggle room in terms of this, acknowledgement of receipt of request. If someone is requesting a number of documents that extend back years and years, public entities may exercise a 14-day extension, but these are really limited for unusual circumstances. And it's always been my practice not to exercise that 14-day extension, but understanding that sometimes you just have to. So one of the recent updates that the Public Records Act, had occur was the state Supreme Court issued an opinion in the case of the City of San Jose versus Superior Court. And this came out a few years ago, which really extends the idea of a public record, existing in that paper sense or in the agenda sense, and really bringing it into the realm of social media. So what the court focused on was no longer can we think that, these records only relate to paper, but really now could include a city employee or a commissioner's comment or communication on Facebook, Twitter, Instagram, on a personal text message sent from a personal cell phone after hours, or on a personal email account such as Gmail or Hotmail or any other kind of personal email account. The test here in determining whether that communication rises to the level of being a public record is whether the post, the text, or the comment substantively relates to the conduct of the people's business. So let me give you an example of some communication that probably won't rise to that level. The court focused on communications that were primarily personal and really didn't have more than an incidental reference to the employee, the city employee or commissioner's job duties. So for example, if we take the following example of a text message, if a city employee or a commissioner were to send the following, quote, "On a break, this commission meeting is still going. I'll probably be late to dinner." In my mind, I wouldn't consider that text to rise to the level of being a public record. Again, there's a reference to the commission meeting, but really it's brief, and the message itself is brief and really seems to just be informing the recipient that, hey, I'm going to be late. However, if we take that same text and we add to it and change the facts a little bit, we have a different outcome. So same text, but then we add, we're really focusing on the need to, for state guidance regarding pedestrian improvements near schools and whether the city has procedures consistent with this guidance. That text is of a different color and probably pushes in favor of becoming a public record and being construed as a public record. So in this event, if the public asked for all communications regarding, pedestrian improvements near schools, this text arguably may fall within the category of being a public record and is probably going to be responsive to the request. However, the court really went into greater detail and established a 5-pronged test to determine whether that kind of a text, I'll back up really here, whether this text does in fact rise to the level of being a public record. Some of those factors include whether the employee sent it within the course and scope of their duties, who was the audience, what was the context of the conversation. So I want to make sure that commissioners understand, and staff that are on the meeting, that there is an additional layer and there are additional factors to apply before the city would determine that this second example rose to the level of being a public record. So typically, let's take this further. Let's say that there was a request. The city would then need to have a review process underway, asking staff members and potentially commissioners whether they had any communications that were responsive to the request. And in that exercise, all the records that are responsive must be disclosed unless it's in the public interest to not release. And this is where courts will look really narrowly on what cities may withhold. So on your screen, you'll see a list of exemptions or types of communications or documents that may be withheld and kept from requesters. But again, these are very narrow. Real estate appraisals, pending litigation, any kind of business license information about gross receipts. This is an enumerated list, and again, courts really look at this narrowly. So these are we don't have a wide maneuvering room when asserting these exemptions. So typically, if there's a request for, like I said, all communications regarding improvements, pedestrian improvements near schools, and let's say that there's a thought that maybe commissioners or staff would have them on personal devices, what typically happens, the city does not want to search your Facebook account or go through your personal device. What will happen is city staff will work with folks who staff feel may have responsive records, and the owner of the account or the owner of the device will go through the device and search through using search terms many times that staff will provide. For example, if the commissioner thinks that a commissioner may have a post on Facebook that may be responsive, we could supply search terms to the commissioner, and the commissioner, not staff, would review the commissioner's personal Facebook page or potentially a cell phone for text messages. And depending on the nature of the request, there may be a need to have the person doing the search sign a declaration explaining what personal device you searched or whether you searched a social media account and whether you found anything responsive to the request. And that concludes the portion about public records. So now I'll hand it back over to Celia to talk about fair process.
Caught myself that time. One of the reasons it's so important for us on public records to require you to search your own devices is because the court didn't like the idea that you could do one thing on a public device and then hop off of it and do something else on a private device, which is why now all private devices are subject to disclosure for under a Public Records Act request. And the reason that we have you sign a declaration is because if you're doing the searching, we need to be able to rely on that when we go to court. Because anytime we go to court and make a representation that we've searched all our records, we're going to need your assistance in doing that. The second thing is when we get all of our public records together, if we decide not to disclose some, if we decide we have a responsive record, but one of those exemptions applies, we have to state who the person is that made that determination, that they're not going to turn over that record, and what the exemption is. So public records is a very time-consuming area for the city. We spend a lot of time on it, and we have a lot of people who specialize in it. And I know there's a lot of questions about it because just like everything else, it's an evolving area, particularly with respect to technology. Okay, I'm going to land the plane, as they say, and talk a little bit about fair process. Fair process, as you recall, is a little bit broader than what we call under the Political Reform Act. You all know about the Political Reform Act because you fill out your Form 700. What the Political Reform Act says is we're going to follow the money, and if you have a personal financial interest in a decision, we're going to disqualify you from making that decision. So that can be if you have an interest in a project that's coming before the commission because you have a business interest or you have a property ownership interest, et cetera. Any kind of financial interest will automatically disqualify you. But what happens to all those interests that may not be financial interests? But they're really about fair process nonetheless. And it's a little bit of a grayer area. And most of the law we have in this area is called common law conflict or law that's been made by case law as opposed to by statute. So that's what I want to talk a little bit about under here, because we have some guidance from the court that came down recently, and we don't often get guidance in this area. So the Political Reform Act is really easy because it says if you have a personal financial interest, you're disqualified. It won't let you use public office for private gain, right? That's the whole gist of it, is you're not going to be able to do that. But then we have all these other things that require you all as decision makers, and you may not be the final decision makers, but you are making substantive recommendations on both projects and policy. So you have a wide array of what you do. And the law wants you to use best practices in doing that. So best practices means before an item comes to you, you want to make sure that you're avoiding statements like your mind is made up, or I'll never approve that, not a chance in heck. You really want to think about fairness. This isn't about your personal opinion. It's about applying the city's laws and standards fairly to a set of facts, if you're talking about a project. And you want to make sure that you have an open an open mind, which really means listening during public meetings. You don't want to be out on the streets trying to gather some information that your colleagues don't have access to. And we'll talk about that in a minute. Because what is due process? Next slide. So due process at its heart really requires notice and opportunity to be heard and a fair and impartial decision maker. So that's what everyone is entitled to, and it's really easy. Just pretend it's your project and someone's going to be judging or making recommendations on your project and your property. Think about how you would want the people who are going to be making those recommendations to act. And I always say, just picture yourselves when you're on these quasi-judicial projects where you're making recommendations. Picture yourself in a black robe and think about how people have an expectation from you. They have an expectation that you're going to be fair, open-minded. You're going to apply the law to their project just like you would any other project. It's not going to be informed by any personal bias or personal opinion, etc. So that's what we're really after here, is making sure that you can approach a project fairly. Next slide. So in terms of different kinds of bias that you have, a specific prejudice, this could be based on a relationship, it could be based on a view corridor. So if a project is in close enough proximity to your house, it's likely going to be considered a personal financial interest because there's a presumption that your property value will go up or down 1 penny. But let's just pretend it's in the vista and it's still going to impact your project. You might have a presumed bias or a perceived bias for the project. Similarly, you might have one for an applicant or the person before you, whether that's based on a family relationship or a previous bad experience, et cetera. And so you really have to make sure, gosh, can I approach this project can I set aside those feelings or that experience and approach this project fairly? So that's what we really want. We just don't want any closed minds. Next one. So I think I just covered this. We talked about the Clark decision. So let's talk about the new one. Recently, we sent you out a memo. We sent it to the city council and we sent it to all the boards and commissions about this case, the Petrovich development case from Sacramento. And this is a really interesting case because it's the first time that we've been given guidance in a long time on this subject of bias. So we've always known that projects could be overturned in cases where a decision maker turned out to have bias against a project. But those have all been like planning commission decisions mostly. And this is the first time we've really kind of gotten new guidance from the court. I will say that some people tried to get this case depublished, but it has remained published and it is controlling precedent for us currently. And the reason they did that is because there's so many factors that people consider in trying to determine bias, which is why it's always better to catch on the front end. So in this case, what happened is even at the planning commission level, one of the gentlemen who was going to ultimately hear the case on the council was actively involved. He didn't like the project. He lived close to the project. His homeowners association was against the project. He had already stated that he had trouble with the project, but then he went a little bit further than that. He actually assisted the opposition in developing arguments against the project. He actually put together talking points for the opposition to use. He tried to secure votes from his colleagues in advance, which let's forget about the Brown Act violation also. And he organized the whole presentation, like the order of the presentation, because he told people that he had the votes to deny the project. So what happened is the court said, interestingly, that the proximity of his home to the project was not a problem. It also said his membership in the homeowners association that was opposed to the project was not a problem. And his expressions of concern, where he didn't indicate his mind was made up, were not a problem. What was a problem? All of the affirmative steps that he took to assist the project opponents. And I would submit to you that that would also include affirmative steps that you take to assist a project proponent, right? Because you're not supposed to be engaged in advocacy in the role that you're currently sitting in. And that's exactly what they said. They said that he also organized the opposition, that was not allowed, and he acted as an advocate against the project. So this is pretty interesting. We often get reports in my office that a commissioner or a council member or somebody is out there mixing it up with the opposition, et cetera. And I've always sort of, so long as it wasn't really a prejudgment issue, you know, a lot of that I consider politics, or have been considering politics in a neighborhood. But that is not what this court says. What this court says, from now on, you need to make sure that you vet those things and make sure that you gauge your behavior appropriately, so that it doesn't appear that the people coming before you are not going to get a fair hearing from you. So what's the best thing to do in that situation? Just recuse yourself. If you don't feel like you can be fair on a project, you literally have the ability to compromise the entire board's or entity's legislative body's decision on it. And that's what happened in this case. There may have been only one biased person, but the entire decision was thrown out and the case had to be reheard in front of impartial decision makers. So that's a pretty interesting development in our area. And I think we're done with the slides. And I hope we have at least a little time for questions. If not, I'm just going to encourage you to come back for an AB 1234 full 2-hour training.
Thank you, Attorney Brewer and Contreras. Commissioners, any questions? Commissioner Fowler?
Yeah, I have tons of questions, but I'll only do one that's very interesting. So it has been my practice over time to discuss agenda items and how to deal with them. And I will say, not necessarily how to vote on them, but generally, because it's hard to begin this kind of activity not knowing anything. It's very difficult for the first year. Mm-hmm. And so I have a friend who does not live in the city, nothing, you know, but I do discuss specific things that I have questions about and may have texted about it as well in some detail. So, the question, what came up during the slide, I think it was Robert's slide, that it just seemed without any reference to the person you're communicating with. Implied is that it seemed like it was, you know, you can't do it to, couldn't call up, Chuck and say, hey, Chuck, what do you think about blah, blah, blah? It's on the agenda. But if it's somebody who is just an advisor, maybe my father, for example, or whatever. So does that violate the Brown Act? And even more important, would I be asked to search through my emails and text for evidence that I had discussed it? And what if I refused? What if I just said, hey, look, you could go to Google and petition them to find out whether I did it, or AT&T, or actually I use Google Fi. So go to Google and get all that stuff.
So I've never actually had to talk about what I'm going to do if I have a vigilante board member who doesn't want to comply with the law. But let's just go back to a couple of other things that are potentially troubling or that you might want to think about in your situation. Number one is, because they're substantively dealing with the project, I would be inclined to, not knowing anything else, we take the records on their own, consider them public records. Number two is, you're gathering evidence outside of a hearing. If that's a legislative matter where you're all formulating a policy, that might be very appropriate. But if it's a recommendation on a project, a quasi-judicial process, then that's probably not appropriate, because what's happening is you're considering evidence that's not in the record. The applicant isn't aware of it. So let's just pretend your judge was going off somewhere and gathering evidence outside of the courtroom. you'd be a little bit upset if you found that out. So that's something that's a little bit troubling to me. And then the third thing you want to think about is we generally encourage all of you as people who are making recommendations to rely on licensed, bonded, wet stamped plans, experts, expertise, et cetera. We want to make sure that the evidence that you're hearing and that you're basing your decisions on is something that I can defend in court, which means I want to have nice, credible evidence from experts and licensed appropriate people. So those are the kind of the issues that come up with that. Having said that, if you're just trying to say, hey, how should I bring this up in a public meeting? Give me some personal counseling. While it may turn into a public record, I don't know that it would violate the gathering evidence standard. So those are just some of the things you might want to think about. And you always can call our office if you want to talk about it further. The one thing I wouldn't recommend, though, is refusing to comply with the Public Records Act request, because then what happens is we get sued. And then I would have to say, well, I don't know how exactly it would go. If you failed to comply and we were sued, then we're responsible for all the attorney's fees if the request does result in records. And if it resulted in someone acting outside the scope of their office, for instance, by not complying with the law, then I don't know if there would be personal liability or not, but I've never researched that, but you'd want to avoid that at all costs, I would think.
Yeah, I actually had to live through that, Celia. So Commissioner Fowler, we had a response before coming to Carlsbad in my last job where apparently the records didn't exist and records were deleted. So I had to represent that to the attorney who filed the request on behalf of the attorney's client. When I told that to the attorney said, no, I have a text message here sent from someone inside the city. Release the text to me. So I was in the awkward position of having to go back to the staff person and say, hey, did you search your phone okay? Because the attorney's saying that there's a text. Oh, no, I deleted my text. Okay. I went back, relayed that the text had been deleted. City was sued. Only after the city was sued for failure to release a record that was otherwise, the attorney claimed, subject to disclosure, I had to go back to this employee and say, hey, okay, we've been sued. Are you sure you deleted it? If you did delete it, please tell me the date. Please give me the circumstances. Were you cleaning out your phone? Let's go through this the facts here of when it was deleted. So what happened was, once I started to play out the scenario, okay, we'll submit a declaration. There'll probably be written discovery. You'll answer these questions under penalty of perjury. Then you'll be deposed based on the answers you provide under penalty of perjury. The document suddenly appeared. And we released it, but the damage had already been done. The city failed to release a record promptly, and the litigation was the moving impetus that finally got that staff person to release the record. So we had to pay attorney's fees. And that's what we do not want by any stretch. So I, to this, would echo Celia's comment about please call us, because many times, like I said, there's a 5-factor test to determine whether something is a public record or not. And so by discussing that ahead of time before we say, I'm sorry, a text has been deleted, could really save the city a lot in terms of attorney's fees.
And I will just give you a pro tip. Many times when we get Public Records Act requests, the reporter or someone else already has the record. They're trying to protect their sources. So they often already have the records when we get the Public Records Act request. Any more questions? I love this stuff. I could do it all day.
Commissioner Lanky?
Yes, so I want to pick up on the comment about having to rely, not doing your own research and having to rely entirely on so-called experts. So it's no secret to this commission and probably everybody here that I do a lot of research, and I have, I think, over the years compiled a lot of evidence that the experts don't necessarily know or portray an unbiased portrayal to the commission. And so I'd like a clarification on whether we're being told we can't do anything
Oh, I'm sorry. No, I want to clarify that.
Okay.
So there's two different types of things you do. So if you're working on a policy document, for instance, if you're talking about how do we count ADTs in the city or VMTs or all these new things that you all deal with, and you're really trying to formulate a method going forward, in that case, that's very appropriate to do your own research. You're really trying to gather all of the facts that you know, your community input, et cetera, and try to come up with a policy that it's informing you in that policy. Where it might be very inappropriate is if what you're trying to do is put together a record of a decision-making record, and when you're going to make recommendations on somebody's project. And the reason I say that is it's not fair to the applicant, it's not fair to the staff, it's not fair to your fellow decision makers if you're relying on evidence outside of the record in making your recommendation. So the important thing to do then is to bring that evidence into the record. And that's what ex parte disclosures are about. You want to disclose everyone you've talked to about the project. And that's also where you need to get it into the record in terms of taking what we call disclosures, ex parte disclosures, and saying, not only have I talked to these people, but here's some additional materials that I discovered. I want my fellow commissioners to be able to consider these. I will say, though, when it comes to what we call substantial evidence may or may not include the testimony of, for instance, a citizen may not be given the same weight in terms of credibility in a judicial setting as a licensed expert. So when I say I'm always looking to make sure in defending the council decision or defending your decision, you want to make sure that your decisions have that factual basis. And sometimes we have a lot of people, it's funny, amazing how a lot of people are attorneys and traffic engineers out in the public, but they're not attorneys and traffic engineers who have their licenses on the line, like the people that we're hiring, right? So that's what I'm looking for. So I want to have a record that includes those people. So I hope that clarifies your question.
Thank you.
Thank you. Any other questions from the commission, from the commissioners? No? Okay, well, I appreciate the information, and thank you very much, council.
You're quite welcome. Make sure you sign up for your AB 1234 if you're due. You'll get a thorough update. Make sure you have open and public 5. If you don't, then the city clerk will be happy to provide you an electronic copy of that document. And thank you very much for having me. And I appreciate all the hard work you do for the city of Carlsbad. And I really appreciate how technical you all are. I'm glad it's better you than me. Thank you.
Thank you. Okay, so right now I'm showing 5:16. I know our next topic is going to be a pretty lengthy discussion, so I'd like to for us to take a break, say for 10 minutes. We can take a break right now at 5:17 and maybe reconvene at let's just say 5:30, if that's all right. Okay, so we'll be back reconvening at 5:30.